Welcome back to the Master Tree Farmer series, Preparing for the Next Owner. We're going to continue with Sarah Clingman, but before we continue with her presentation, we're going to take one of the questions that we've gotten. I know some of you have seen some 800 numbers that have been on the screen. There's also fax numbers and things. You can send your questions to us by those means, and we will try to get to those questions. And if we don't get to them here, we will have a special question and answer session that will be playing a half hour before the start of the program next week, where you'll see some answers to these particular questions. This one comes from Virginia, and it has to do with mineral rights and oil and gas rights. Can you comment about that, Sarah?
Sure. We don't have as much of this as many other states do, but there is the ability to convey less than that bundle of rights, and sometimes that involves the right to mine or take oil, minerals of any kind from the property, and that is created by deed just as a right to any property is. And that becomes important when you're considering conservation easements, and there will be a whole session on conservation easements later, and I'm sure that they will address those at that time, but if not, during the panel discussion we'll make sure to cover that.
Okay. Why don't we go ahead and get started then? We're going to continue to talk about estate planning, reasons for planning, and then several other topics that relate to this here. So Sarah, continue on with us, please.
Okay, thanks. There were a couple of questions that came in that I'd like to address very quickly. The first was from Winsboro, and they asked about the need to have a lawyer to sell property or to quitclaim property. A quitclaim deed is a deed that says, if I own anything, I give it to you. So I could give you a quitclaim deed to every tract of land in Pickens County, and you get what I have, which may be nothing, may be everything, you just don't know. And the question is, do you need a lawyer to do that? Well, you don't have to have a lawyer to do that, but it's probably not wise to do that without the assistance of legal counsel. To sell property, you want to make sure that you are giving appropriate warranties of title, and we didn't talk any about warranties of title because of time constraints and limitation, but one of the warranties that you're making is that you own the property if you're giving a full warranty deed. You may need to give a limited warranty deed or a quitclaim deed. And if you're giving a quitclaim deed, you want to make sure that there is appropriate language in there addressing what rights, what obligations you have in that deed. And so I would recommend, it's relatively inexpensive, I would recommend that you have a lawyer to draw that up so that you're doing exactly what you think you're doing. The second is title insurance needed only if buildings are on property. My experience has been that title insurers are reluctant to insure open land. Title insurance is needed on open land. If you can find a title insurer that will insure open land, by all means get it. If you are mortgaging a piece of property, the bank will require title insurance generally, and generally that's a residential property or a commercial property that has an improvement on it. So check with your attorney, title agent, to see if that title insurance is available on open land, and by all means buy that if it's available. Now we're going to talk about basic estate planning. The first thing to consider is why you're planning. What are you planning for? First thing we want to make sure of is that you get to transfer your assets to the people you want to get them. If you die without any estate planning done, the state is going to decide who gets them. The intestacy statute is going to decide who gets them. You can also control the manner in which your loved ones get the assets and how they use them. And this is very important for some people. They want to make sure that property is used in the way they want it used and under the conditions they want it used. And very often I'll get folks who come in and they want to have a trust for their children. And I say, okay, when are we going to distribute the assets in the trust? And they say, never. When will your children become financially responsible? What age? Never. There is some point in time at which you're going to have to trust them to be able to handle things, and you may be able to control it one generation, but you're not going to get away with controlling it in perpetuity unless you do some things that Tom is going to talk about in a little while that'll give you more control over it. The other thing is to avoid taxes, income taxes, gift taxes, and estate taxes. With the estate tax exemptions going up, estate taxation is not the issue that it used to be with forest land, but there are other kinds of taxes that we want to minimize in doing estate planning. And we want to minimize or reduce the cost of estate administration. And what you say is the cost of administration. Well, there are fees that you have to pay to the court depending on the value of the estate, but there are also attorney's fees. In some jurisdictions, they are statutorily set as a percentage of the estate. In this state, they're negotiable. They're generally hourly rates. Sometimes they have to be court approved, and the court approves a lower hourly rate than the attorney might ordinarily be able to charge. But the bottom line is a long, expensive process to go through probate. We want to make sure that the property is distributed in accordance with your wishes, that we're not going to do anything with your property that you didn't already think through and decide that's what you want done. We may need to create estate liquidity. We may need to have money available to pay taxes with, to pay debts, to pay administrative costs, and we want to make sure that we decide who is going to be the personal representative or the executor, who's going to take control and marshal all of those assets and distribute them in accordance with your plan. We want to make sure that you have the basic estate planning package. Every one of you should have this. Wherever you are located, you need to have a will or a trust agreement that says where your stuff goes when you die. You don't have to tell anybody else in the world who's getting your stuff when you die. Everybody says, I want to treat my children equally. They'd never fight. They're sweet little babies and angels. But if you decide you want to leave one of them your property and not leave the other two anything, you don't have to tell them that. They can be mad at you after you're gone. You're dead. Don't worry about it. The next thing you need to have is a general durable power of attorney. It is a document that gives another person the authority to do things for you if you're not able to do them for yourself. Even if you are able to do them for yourself, they can do that. They take this document, which is generally financial in nature. They're able to go to your bank, sign checks, take over your bank account, withdraw your money. They can sell your property. They can do anything at all that you could do yourself. Now, this is a document of extreme trust. You have to trust the person who you are giving this document to. The attorney, in fact, is a fiduciary. They have a fiduciary obligation to do what's in your best interest. But that doesn't mean they can't take your money and go to Las Vegas and gamble it all away. So you need to choose carefully when you select your fiduciary, your power of attorney. And then you need to have advanced medical directives that say who gets to decide if you're going to have medical procedures, if you need medical treatment, what you're going to have, and you need to have a living will that says what you want at the end of life, whether you want to be kept alive artificially. If you are in a second marriage, particularly if you're older and you have grown children from previous marriages, it is very important to consider the consequences of what this is going to do in terms of estate planning. You may decide that you want to leave everything to your new husband because you love him and God bless him, he's just going to give it to your children when he dies. Well, that doesn't always happen. And very often we end up litigating away in attorney's fees every penny that was in that estate. So making good plans ahead of time eliminates family discord, it eliminates unnecessary expense.